23 February 2019, the forfeiture proceedings in the two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against Usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment, such as fine, for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money, after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction-based forfeiture, being civil in nature and an action in rem, can in no way be equated with a sentence of imprisonment or fine imposed for an offense involving dishonesty or fraud or for any other offense to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Grant 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1)(8), will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC Regulations and Guidelines for the Conduct of Elections 2022, the first respondent made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provides that at every level of collation, where any copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collate results. It is therefore not correct that it shall not be possible to collate results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act prevails. See Odeneye against Efunuga in Yesom against Peter citation supplied, Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECATA at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers, so as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election, if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the results were still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Acts provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agents raises a presumption that if those forms had been produced, it would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified, claimed to be a software engineer and an employee of Amazon, she had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby JSC in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, if there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abubakar and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. CLLU, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goals set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14(1) and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution being urged on us by the petitioners is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention in that regard, and unfortunately, they found a ready alliance in those who should know better. The interpretation being or not is squarely against the letters and spirit of our Constitution, and it is hereby rejected. Based on the above and the further reasons lucidly explained in the lead judgment, I too dismiss the petition. 04. I have had a preview of the reasons given in the lead judgment of my learned brother. I agreed with his reasoning and conclusion. I adopt same as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third ground, and I also dismiss the petition. On the whole, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother,